Before we introduce Commissioner Brown as the editor of the minutes, I want to take this opportunity to recognize a very special guest who's joined us this week at the Commission, Hideki Komotera. It's a pleasure to welcome him to Pennsylvania. Just by way of background, he's visiting the PUC as part of the United States Department of State International Visitors Leadership Program. He's currently on a sabbatical from his position at the Ministry of Economy and Trade for 1 year. And since his journey here to the U.S., he's had the opportunity to visit the Massachusetts and New York commissions. And I'd like to say their capacity versus our capacity, it's kind of like night and day. Just kidding. His particular areas of focus during his journey here is to exchange ideas and improvements in the reliability of the electric supply and examination of transmission and distribution systems here in the U.S. And I'd ask everybody to please join me in extending a warm Pennsylvania Public Utility Commission welcome to our guest, Hideki Komotera. The first matter on this morning's agenda is the approval of the minutes of the October 23rd meeting, and it's a pleasure to recognize Commissioner Brown as editor of the minutes. Commissioner Brown.
Good morning, Mr. Chairman.
Morning.
I have reviewed the minutes of the October 3rd, 2014 public meeting, and I move that they be approved as submitted.
Second. Any discussion? Any objections? Hearing none, the minutes are approved as submitted. It's a pleasure to welcome to the podium this morning to commence with public meeting is Ms. Cheryl Walker Davis. Good morning, Cheryl.
Good morning, Mr. Chairman. Good morning, Commissioners.
Good morning.
Is it safe? May it please this honorable commission, on behalf of your various offices and bureaus, we present for your consideration and disposition the following agenda items, commencing this morning with matters on behalf of the Bureau of Audits. It is recommended that the commission adopt all of the items appearing on page 1 of the agenda through and including the recommendation to release the audit report involving the PPL Electric Utilities Corporation transmission service charge.
So moved.
Second.
Any discussion? Any objections? Hearing none. The motion is approved as submitted.
On behalf of the Office of Special Assistance, commencing on page 2, it is recommended that the Commission adopt the items commencing with the recommendation involving Taxi Express LLC at the top of page 2 and continuing through and including the first item at the top of page 3 involving the complaint proceeding of William McLucky versus Palmco Energy PA LLC.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
We recommend the adoption of the staff recommendation pertaining to PECO Energy Company's default service plan, noting the statement of Commissioner Brown.
So moved.
Second.
I'd like to recognize Commissioner Brown for purposes of her statement. Commissioner Brown.
Thank you. On August 28, 2014, the parties to this proceeding filed a joint petition for partial settlement. The parties failed to settle on 2 terms for 2 specific issues. The first issue pertinent to this statement relates to whether PECO should assume responsibility for PJM charges for the network integration transmission surcharge for all customer load, both shopping and non-shopping, and recover those costs through a non-bypassable transmission charge. I believe that requiring EDCs to assume the cost responsibility associated with these non-market-based PJM charges for all load removes additional costs from the price customers will pay. This is the case because, unlike an EGS, an EDC is permitted to recover on a full and current basis all reasonable costs incurred to provide default service. The second issue, which is not settled, regards procurement of default service supply for the medium commercial class. PECO initially proposed structuring this class default service through 6-month contracts. However, PECO later indicated support for hourly price default service for its medium commercial customers to the extent interval meter installation permits. PECO offered this change to comply with the Commission's direction in the RMI order that customers with interval meters and peak demands above 1,000 kilowatt be moved to hourly price default service. I wish to note that the RMI order recognized that the Commission was trending treading a fine line between setting market-reflective competitive policies and complying with the prudent mix procurement language in Act 129 of 2008, which reads, while the Commission is steadfast, what reads in the RMI order is the Commission's statement of, while the Commission is steadfast in its view that our decisions to permit spot market approaches in specific situations are appropriate, we are concerned that a general pronouncement directing a 90-day product for residential and small business customers and an hourly LMP product for medium C&I customers may raise legal questions about compliance with the above referenced provisions of the Competition Act. To avoid any legal uncertainty, the Commission would prefer to pursue legislative amendments that clearly provide the authority to approve default service plans containing products that more closely resemble current market conditions at the time of delivery, end quote. As noted in the RMI order, this commission is a creature of the legislature and as such is well served to ensure that the General Assembly is supportive of our overall policy on matters as important as retail market for electricity. The then sitting commission, which approved the RMI order, stated its intent to seek legislative changes that afford the commission the flexibility to make this kind of questionable policy change. Those legislative changes have not yet been made. Therefore, I had to weigh this issue carefully. Having noted my concerns, I still conclude that the partial settlement does succeed to establish a default service plan that satisfies the procurement requirements under Act 129, specifically Section 2807E of the Public Utility Code. This provides that a default service provider must procure electric power via a prudent mix of spot market, short-term, and long-term contracts designed to ensure adequate and reliable service at the least cost to customers over time. PECO's proposed default service plan includes spot market products in the residential, medium commercial, and large commercial and industrial portfolio, short-term contracts in the residential and small commercial portfolio, and long-term contracts in residential, medium commercial, and large commercial portfolio. The mix of contracts is by no means an exact science, but I note that if the default service plans were in place during the recent polar vortex, had been priced solely on short-term or hourly contracts, default service customers would have been exposed to extreme pricing volatility. Because PECO's overall plan includes a prudent mix sufficient to satisfy Section 2807E of the Code and the court's ruling in Propalski versus the PUC, I will vote to approve the hourly price default service for the medium commercial customers. I note that none of the default plans that I have voted on during my tenure include new long-term contracts, only long-term contracts inherited from previous default service plans. These grandfathered contracts will eventually expire. I wish to clarify that, in my opinion, it will be incumbent upon the EDCs and this commission to carefully consider long-term contracts of 4 to 20-year terms consistent with Section 2807 of the Code and future default service plans unless the legislature decides otherwise. Thank you.
Thank you, Commissioner Brown. Is there any further comments on this particular case? Hearing none, the motion passes unanimously, noting the statement of Commissioner Brown.
In omnibus fashion, it is recommended that the commission adopt the items commencing with the staff recommendation at the top of page 4 in the complaint proceeding involving the Bureau of Investigation and Enforcement versus Penn Eastern Rail Lines, Inc., continuing with the remaining item on page 4 and all items appearing on pages 5, 6, 7, 8, 9, 10, 11, and 12 through and including the recommendation with regard to Verizon Pennsylvania LLC and Finger Lakes Technologies Group.
So moved.
Second?
Any discussion? Any objections? Hearing none, the motion passes unanimously.
On behalf of the Bureau of Technical Utility Services, it is recommended that the commission adopt all items appearing on pages 13, 14, and the first item, that is through and including the recommendation with regard to the application of American Broadband, Inc. at the top of page 15.
So moved.
Second?
Any discussion? Any objections? Hearing none, the motion passes unanimously.
It is recommended that the Commission adopt the staff recommendation in the matter involving the application of Pennsylvania American Water Company for approval to extend into additional portions of Buffalo Township, Washington County, PA, noting the statement of Commissioner Whitmer.
So moved.
Second.
I'd like to recognize Commissioner Whitmer for purposes of her statement. Commissioner Whitmer.
Thank you, Mr. Chairman. I'd like my statement entered into the record as if I had read it in its entirety. Today, we approved the application of Pennsylvania American Water Company to extend water service to additional portions of Buffalo Township in Washington County. The extension will intercept 61 residential customers as well as 3 commercial customers at the cost of $2.9 million. And I'd like to note that these costs will be borne entirely by Pennsylvania American. I note that the application indicates Pennsylvania American's intention to serve the area along Mel Blount Drive, named for the Hall of Fame Steeler cornerback and owner of 4 Super Bowl rings. While it is an honor to have a road named after you, I'm going to go out on a limb, which is a place no NFL receiver ever wanted to be, with Blount on the field for 219 games, and will guess that number 47 prefers having the NFL's still current receiver protection rule named after him. All football fans are familiar with the Mel Blount rule, right? Right? Okay. But for those who may not be attuned to such things, Blount is known as the impetus for the rule prohibiting receivers from being sort of bumped within 5 yards of the line of scrimmage. This rule is commonly referred to as the Mel Blount rule. So kudos to both Pennsylvania American for not sitting on the sidelines and extending the field of play by providing a safe source of drinking water to additional customers, and to Blount, who is helping troubled youth through the Mel Blount Youth Home located on Mel Blount Drive. One suggestion, though, for Pennsylvania American: when you're repaving Mel Blount Drive, consideration might be given to paving it with gold paint on the black pavement. Thank you, Mr. Chairman.
Thank you, Commissioner Whitmer, and I'll have to talk to my friends down in the Southeast who are Philadelphia Eagles fan and make sure Aqua or one of my other water companies can follow suit.
Yeah, see, the problem is there's no green asphalt.
That is true. Is there any...
No rings.
And no rings, but I do want to note for the record here this morning, if we're going to have this debate at the bench, who has the better record. So with that...
This year might be tough.
With that in mind, is there any further discussion? Are there any objections? Hearing none, the motion passes unanimously, noting the eloquent statement of Commissioner Whitmer here this morning.
Continuing with the presentation of items on behalf of the Bureau of Technical Utility Services, we recommend the adoption of the remaining 2 items on page 15 pertaining to the application of Blue Rock Energy, Inc., as well as the Columbia Water Company Supplement Number 68, as well as the first item at the top of page 16 pertaining to North Penn Telephone Company's rate rebalancing filing.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
It is recommended that the Commission adopt the staff recommendation with regard to the PECO Energy Company Supplement Number 152 with regard to revising the penalties associated with the unauthorized use of natural gas by commercial and industrial customers, noting the statement of Commissioner Cawley.
So moved.
Second.
I'd like to recognize Commissioner Cawley for purposes of his statement. Commissioner Cawley.
Thank you, Chairman. I asked that my statement be placed in the record as if I had read all of it. This is a tariff by PECO Energy Gas proposing to revise the penalty for unauthorized use of natural gas by commercial and industrial customers. The problem sought to be addressed is of 2 types. One occurs when transportation customers consume more gas than is delivered to the city gate. And the second occurs when an interruptible transportation customer consumes natural gas after the gas has been cut or curtailed, or when firm sales customers consume more gas than they are entitled to and that they have paid for under their firm sales contractual entitlements. Both of these problems are a problem simply because it's unfair to the rest of the customers when for instance, an interruptible customer continues to use gas when it is told to curtail. In response, this proposed tariff proposes to increase unauthorized natural gas use penalties, and it modifies the definition of a, quote, market rate to better reflect the actual cost of gas during a curtailment period. These are commendable attempts to solve these problems. The problem that they unfortunately create is that these penalties are passed on to customers or are passed on to these customers' customers, and it has the effect of increasing natural gas volatility and even because natural gas is used very often to generate electricity, it increases electricity prices. So what we have, unfortunately, is a penalty race which customers end up paying for. Again, I commend the parties for trying to solve this problem, and I'm going to reluctantly agree to approve this filing, but there's got to be a better way to solve the problem of these customers who are not delivering enough gas to the city gate, or they're continuing to use gas when they're told to curtail. For the time being, I will vote for this and hope that technology or some other more creative solution is arrived at in the future. Thank you, Chairman.
Thank you, Commissioner Cawley. Is there any further discussion? Are there any objections? Hearing none, the motion passes unanimously, noting the statement of Commissioner Cawley.
It is recommended that the Commission adopt the staff recommendations, the remaining two staff recommendations on page 16 with regard to Canterbury International doing business as two men and a truck, as well as Mooney's relocation specialist, as well as the staff recommendation at the top of page 17 in the application proceeding involving Convenient Ventures LLC, DBA Energy Objective.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
Mr. Chairman, I'd like to recommend in tandem the next two items, those being the staff recommendations in the application proceeding of Hamilton Relay, Inc. For approval to offer telecommunications relay services for the deaf and hearing impaired, as well as the application of AT&T Corporation for approval of the abandonment or discontinuance of telecommunications relay services, noting the statement of Commissioner Brown with regard to each of those items.
So moved.
Second.
I'd like to recognize Commissioner Brown for purposes of her combined statement here this morning on these two cases. Commissioner Brown.
Thank you, Mr. Chairman. Today's decisions approve the application of the Commonwealth's new provider of telecommunications relay service, a service that facilitates the delivery of telecommunications to deaf, hard of hearing, and speech impaired individuals. It also approves with conditions abandonment of the AT&T's obligation to deliver TRS. Our new provider, Hamilton Relay, has a solid track record of providing TRS in multiple states around the country. Our current provider, AT&T, has been an excellent provider of TRS from the time the Commission implemented TRS over 20 years ago, in a collaborative effort with carriers and the Pennsylvania Telephone Association. As a result, Pennsylvania's TRS was up and running well in advance of the federal law on TRS. The statutory obligation to provide TRS is a duty of telecommunications common carriers, not the Commission's. Because the Commission procured the TRS service on behalf of the telecommunication carriers, and because the service is funded by Pennsylvania's ratepayers, I believe that the Commission could have required bidders to locate employees and facilities within the Commonwealth to the extent possible. Requirements of private parties that are also important state objectives are not automatically an impermissible burden on interstate commerce. AT&T was able to do just that for 20 years by working closely with the communication workers of America. Now those jobs and their economic benefits depart from Pennsylvania and will go to 4 other states. While I completely support this new TRS provider and the important service it provides, I wish the Commission had more thoroughly considered ways to keep those CWA jobs in Pennsylvania, given the economic impact sure to flow from their loss. Thank you.
Thank you, Commissioner Brown. Is there any further discussion? Any objections? Hearing none, the motion passes unanimously, noting the combined statement from Commissioner Brown.
Turning now to recommendations presented on behalf of the Law Bureau, it is recommended in omnibus fashion that the Commission adopt all recommendations, commencing with the recommendation involving PA Universal Service Fund at the top of page 18, continuing with the items on pages 18, 19, and 20, through and including the recommendation with regard to the Citizens Electric Company of Lewisburg and Wellsboro Electric Company.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
With regard to the Office of Administrative Law Judge, on page 21, it is recommended that the Commission adopt the recommended decisions of ALJs Fordham and Gould at the top of page 21 in the proceeding involving the Borough of Ambler Water Department, as well as ALJ Barnes' initial decision in the proceeding involving John Crespo versus Philadelphia Gas Works.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
That concludes the presentation of regular agenda items. Turning now to the carry-in agenda. It is recommended at the top of page 1 that the Commission adopt on behalf of the Office of Special Assistance a recommendation in the proceeding involving NRG Power Midwest LP et al. Versus Duquesne Light Company.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
Should be noted that the remaining 2 recommendations with regard to the application of Lift Inc. have been postponed until public meeting of December the 18th. Turning now to the supplemental carry-in agenda, it is recommended that the Commission adopt, on behalf of the Law Bureau, the recommendation in the proceeding involving Mountain Energy Ltd.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
And that concludes the presentation of agenda items.
Before we adjourn here this morning, I want to take this opportunity to recognize a team that worked within our Law Bureau on a really important filing that was submitted in front of the Environmental Protection Agency on Monday regarding the 111D Clean Energy Plan. And I simply want to take this opportunity to thank Buck Panque and Jim Melia and Chris Brown and others and all of our staffs for working collaboratively. This is a very important filing. And again, I just want to thank that group here this morning for the work that they've done. Pennsylvania, again, being nationally recognized for the efforts we've put forth in that filing. And I wanted to, again, take that opportunity here this morning. We also will reconvene here at 1 p.m. For our Business Literacy Series announcement. And again, that will start here at 1:15 this morning. On that note, we're adjourned.